Denzel Washington stood perfectly composed at the lectern in Courtroom 3 of the Supreme Court, his tailored navy suit a stark contrast against the imposing marble columns behind him. Just moments earlier, Chief Justice John Roberts had interrupted his oral argument with an unprecedented challenge. "Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position." The statement sent shockwaves through the packed courtroom. Law clerks exchanged glances, veteran attorneys straightened in their seats, and journalists frantically scribbled notes. But Washington, the award-winning actor who had spent the last 5 years secretly earning his law degree while filming blockbusters, didn't flinch as the 9 justices and hundreds of spectators watched intently. Chief Justice Roberts, with his Harvard pedigree and 16 years leading the nation's highest court, was certain he could expose this celebrity's legal inadequacies. But Washington, armed with a constitutional theory he had developed during his studies and a comprehensive knowledge of case law that would shock the court, was about to transform this condescending ambush into the most memorable oral argument in decades. This wasn't just another Supreme Court hearing. It was Washington's moment to prove that brilliant legal minds can emerge from unexpected places and possibly change American constitutional interpretation forever. Before diving into this extraordinary legal showdown, make sure to like this video and subscribe to our channel so you won't miss our latest coverage of inspiring stories where preparation meets opportunity. The tension inside the Supreme Court had been building since the moment Denzel Washington's name appeared on the docket 3 months earlier, when the renowned actor had filed an amicus brief in Henderson v. Department of Justice, a case involving civil forfeiture laws disproportionately affecting minority communities. Legal circles initially dismissed it as celebrity activism. Few realized that Washington had actually earned his J.D. from Howard University School of Law, studying nights and weekends between film projects, maintaining complete privacy about his educational pursuits. Chief Justice John Roberts, 67, presided over the court with the confident authority that came from a sterling legal career. Harvard Law Review, clerk for Justice Rehnquist, principal deputy solicitor general, and nearly 2 decades on the nation's highest bench. Known for his incisive questioning and occasional sharp wit during oral arguments, Roberts had developed a reputation for testing unprepared attorneys with piercing hypotheticals that exposed logical flaws in their reasoning. When Washington was granted 10 minutes to argue in support of the petitioner, a rare honor for someone filing an amicus brief, the legal community buzzed with speculation. Most assumed it was a public relations move by the court, attempting to appear more accessible to ordinary Americans. But those who had actually read Washington's 40-page brief recognized something the chattering class missed. It contained a novel legal argument about the original understanding of the Fifth Amendment's takings clause that challenged decades of precedent. "I can't believe they're letting him speak just because he's famous," whispered a corporate attorney to his colleague in the gallery. "This isn't Hollywood. You can't just memorize lines and expect to convince the Supreme Court." The stakes were enormous. Henderson involved the government's seizure of a community center and surrounding properties in a predominantly black neighborhood in Philadelphia, based on a single drug transaction that had occurred on the sidewalk outside. The government hadn't charged any of the property owners with crimes, but had seized millions in real estate through civil forfeiture laws. If Washington's argument prevailed, it would dramatically limit government power to seize property without criminal convictions. If he failed, not only would the seizures stand, but his legal theories, developed during years of determined study, would be dismissed as amateur musings of a celebrity dilettante. The courtroom fell silent as Washington approached the podium. Unlike many first-time advocates who appeared nervous before the court, he moved with the quiet confidence of someone accustomed to high-pressure performances. Still, few in the room, perhaps none, anticipated how thoroughly prepared he actually was. "Mr. Chief Justice," "And may it please the court," Washington began, his resonant voice filling the chamber without need of amplification. "The Fifth Amendment's provision that private property shall not be taken for public use without just compensation was understood by the founders to require not merely monetary compensation, but also a genuine public purpose and basic procedural protections before the awesome power of government could be deployed against a citizen's property." His opening was eloquent, but unremarkable. Chief Justice Roberts, who had been reviewing Washington's brief with skepticism, saw an opportunity to expose what he perceived as superficial understanding. While justices typically allowed attorneys to develop their arguments before questioning, Roberts broke protocol, interrupting just 40 seconds into Washington's presentation. "Mr. Washington," Roberts began, his tone carrying a hint of condescension, "while I appreciate your interest in this case, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. Your brief seems to overlook 2 centuries of settled doctrine on civil forfeiture." A murmur ran through the courtroom at the unusually personal nature of the challenge. Justice Sonia Sotomayor shifted uncomfortably in her seat. Justice Elena Kagan frowned slightly. Washington paused, meeting the Chief Justice's gaze directly. Those who knew him recognized the calm that always preceded his most powerful performances. "Chief Justice Roberts," he replied evenly, "I believe my argument is consistent with the historical understanding of the Fifth Amendment as articulated by Justice Thomas in his concurrence in Timms v. Indiana. But perhaps we should examine the textual and historical evidence together?" He opened a well-worn copy of the Constitution, along with several original sources that he, unlike most advocates, had brought to the podium. Something in his methodical preparation caught Roberts off guard. This wasn't the surface-level celebrity advocacy he had anticipated. What followed was the opening move in a legal chess match that would leave the court and the nation stunned by its conclusion. Chief Justice Roberts, realizing his initial dismissal had failed to rattle Washington, leaned forward with a more substantive challenge. "Mr. Washington, your brief argues that the original understanding of civil forfeiture was limited to admiralty and customs cases where jurisdiction over property owners couldn't be established. But you've overlooked the 1827 case of the Palmyra, where this court clearly established broader government forfeiture powers." The question was a trap, one that had ensnared many experienced attorneys. The Palmyra was indeed a landmark case on forfeiture, but its nuances were often mischaracterized. Without hesitation, Washington responded, "With respect, Chief Justice, I have not overlooked the Palmyra. In fact, on page 23 of my brief, I addressed Justice Story's opinion in detail." He flipped precisely to the page without looking. While the Palmyra did permit forfeiture without criminal conviction, it was fundamentally a maritime case involving piracy, where, as Justice Story noted, the vessel which commits the aggression is treated as the offender. This fiction made sense in admiralty cases where personal jurisdiction was often impossible to obtain. Washington continued, his voice gaining momentum. But Justice Story never suggested this exception should become the rule for domestic civil forfeiture against American citizens who are fully subject to the court's jurisdiction. In fact, I've traced every civil forfeiture case decided by this court between 1789 and 1850, all 27 of them. Every single one involved either maritime seizures, customs violations, or piracy. Not one approved the type of land-based seizure from innocent owners that we see in Henderson. The courtroom fell silent. Washington wasn't just familiar with the Palmyra. He had conducted a comprehensive historical analysis that few scholars, let alone practicing attorneys, had ever attempted.